Welcome everyone, both of those of you who are here in person and those of you who are online, to the 42BR Barristers Activism in the Workplace talk. It's great to see so many friends here for what should be a really interesting discussion on one of the real burning issues of the moment. Before we get on to introducing the speakers, if I can just get some of the really important admin out of the way. First of all, there are no planned fire alarms. There was one a couple of hours ago. If the alarm goes, follow us out through the door, and we'll all proceed in an orderly manner outside, and then we can carry on doing the talk out there. Secondly, toilets are just out here and to the right. You'll see them as you go down the corridor. And there are also toilets in the cafe as well, once we go through for canapes and drinks afterwards. Now that all of the important announcements are out of the way, let me introduce our panel to you. First up, to the right, that's not politically, we have Luke Tryl. Luke is the Executive Director of More in Common, who are the groundbreaking polling organisation that constantly find new and innovative ways to understand how the British public think, and also to work out the common ground amongst the societal divisions. And I think my recent favourite was a poll that you did with Barristers Entertainment on which sitcoms different political party supporters prefer over the decades. And I think there was agreement across the political divide that Only Fools and Horses is the best, which is fair enough. Now, Luke's the pioneer of the 7-segment approach to understanding the British population. And he was also the author, I think in February of this year, of an acclaimed report on progressive activism. In Luke's past life, he was special advisor to Nicky Morgan at the Department of Education and the director of strategy at Ofsted. And Luke is a familiar voice in the media. You may actually have caught Luke on Times Radio recording it from one of our pods earlier on this evening during your journey here tonight, or on many of the political podcasts and news programs that he appears on, and especially during conference season. Next up, we have Professor Virginia Mantouvalou. Virginia is a professor of human rights and labour law at UCL, and she's the co-director of the UCL Institute for Human Rights. Virginia takes a particular interest in the most ill-treated members of the workforce, and she's co-written a number of books on structural injustice in the field of worker rights. I think you just said you've been put up for one of is it the Inner Temple Book Award for the latest book on that. Virginia is also the chair of Kalayan, which is an NGO promoting the rights of migrant domestic workers. She has a particular interest in freedom of expression and employee privacy in the workplace. She's written numerous academic articles on that topic and on how employers manage and react to employees' social media output. And she is the co-author of the brilliant Human Rights at Work. And if you don't have that on your bookshelf, you really should. It's sitting by my desk pretty much at all points in time, and I highly recommend it to you. Finally, on our panel, we have Rebecca Thomas, who will need no introduction to many of you, but I'm going to give her one anyway. She's been described in the directories as impressive, brilliant, formidable, talented, highly skilled, astute, thoughtful, and also calm and patient. She's the author of another book that should have pride of place on your bookshelves, A Practical Guide to the Law of Pregnancy and Maternity at Work, which does what it says on the cover. And she's been involved in a number of cases where employees have been disciplined for social media comments, including Web and London Underground, which involved the dismissal of a claimant who had posted offensive Facebook posts about George Floyd and Black Lives Matter, and where Rebecca successfully persuaded the tribunal to reject the discrimination claims and the arguments that were reliant on Article 10 and Article 8 of the ECHR. Now, as for the format of this evening, we're going to begin with Luke and Virginia's talks. Luke first, then Virginia. And after that, we're going to open to questions from the floor, both the in-person floor and also the online floor. If you're joining virtually, please post your questions in the question and answer box, and also give a thumbs up to those questions that you'd like to be prioritized. And those should hopefully, if the tech is working, rise up to the top of the list, and then we can ask the questions that those of you who are watching from home or the office think are the most interesting as well. For those of you who are here in person, we're going to go with the tried and trusted hands up approach and get someone to do the roving mic in due course. Right, those are the introductions. That's the admin out of the way. If I can pass over to Luke to begin.
Great. Well, thank you, Jason, and thank you so much for having me here today. It's quite nice to do this as a bit of a break in the party conference season, because what I've noticed is I'm sort of on the downhill slope of an escalator in terms of the feedback I'm giving the political parties. It started off with Reform UK conference and lots of good news for Reform UK. Might not be good news for others, but certainly good news for them. Then was at the Liberal Democrat conference at the weekend, and they're doing sort of okay, and there's some bright spots. Going to Labour next week, where it's a pretty gloomy picture, and then I have to go to the Tories the week after that and tell them they're facing extinction. So it's quite nice to be talking about something else here. So just before I get into talking particularly about our research on a group that we call Progressive Activists, I just wanted to do a tiny bit of scene setting, because I think it's often in these types of discussions, you can sort of assume that things like activism and attitudes are sort of entirely endogenous, but actually the external environment plays a big role in shaping how people feel about the world around them, and their employment is a key part of that. And when we ask people how they would describe Britain in a word today, the top word that people use to describe Britain is broken. That's followed by mess, divided, and struggling. It is not a particularly optimistic picture. And people's reaction, I guess, to that sense that Britain is broken expresses itself in different ways. So some people, I'll go to it, disengage. Others focus on other areas. Others spend time, trying to change it through volunteering in the community, doing things locally, and others express a desire for change through activism. So I don't think you can separate what we're about to talk about from the external context. And just to kind of, I guess, bring together what is driving that public mood at the moment. Our research suggests there are 4 big factors, and there's more of this if you want to read any more in a report we wrote called Shattered Britain. It's a very optimistic title as well, which is available on our website. But basically it's exhaustion. For too many people, life feels too hard, too difficult. Lack of agency. This sense that government is not in control, and they're not in control of their own lives. Threat perception. This sense the world is becoming more dangerous. And also trust. The sense that people don't trust the institutions that are supposed to help them and support them, including, big business, including employers, including actually for some segments, the law itself. They've lost that trust. So there's some of the drivers of the public mood. And as I said, different groups amongst the public are reacting to this in different ways. More in common, we have a model which we call the British 7 segments, or the 7 tribes of Britain. And these tribes, the way that they're devised is not by demographics, not by partisan belief, but using social psychology. Someone actually described it as horoscopes for pollsters, but I hope it's slightly more rigorous than that. So we use things like Jonathan Haidt's moral foundation theory, Karen Stenner's work on authoritarianism, things like need for chaos, to pull out these 7 groups of the public. And I'm going to particularly focus on progressive activists today, because I think they're at the heart of a lot of the potential conflicts we see around employee activism. But you can see it moves along a scale. And it's interesting, we updated this segmentation recently this year in response to changing societal dynamics. And that segment you see at the other end, we call them dissenting disruptors, are in some ways a counterpart to progressive activists on the right. What's interesting is progressive activists, as the name suggests, express themselves and their worldview through, a sort of battle for social justice, kind of lots of left-leaning causes. Dissenting disruptors actually share progressive activists' sense that we need radical change, but they are much more in the camp of we need to burn it all down in order to make things better. And it's interesting, they're also the two segments, both least likely to say that they are proud to be British, but for very different reasons. Progressive activists often say that they're not proud to be British because they're ashamed of Britain's past, whereas dissenting disruptors say they're ashamed to be British because we've lost what we had in the past. So we're going to be doing a follow-up study specifically on dissenting disruptors over the winter. I mentioned what goes into those segments there. So a mix, as I say, of things like moral foundations, people's levels of online engagement, conspiracy thinking, attitudes to free speech, and multiculturalism. Anyone could go on the website and do the quiz to find out which segment you're in, because I always get asked that at events like this. And if you don't like the segment you're in, please don't come and argue with me about it, because people all do that. And then just very quickly, you can see there the politics of those 7 segments. The progressive activists that we're going to talk about, quite interesting, because you can see that under Jeremy Corbyn, that red line is support for Labour, massive support for Labour. That group have actually been drifting away from Labour since Corbyn led the Labour Party. Labour made gains in other areas at the last general election, and you can see the dissenting disruptors there. They're the group where reform is gaining the most support. But let's look at progressive activists specifically. So that's what I'm going to dedicate the bulk of what I'm talking about to. When you think about progressive activists, the sort of key words that you might use to describe them: idealistic, radical, uncompromising, and some of the people in the other segments would say woke. They are particularly unique amongst the segments because they care about international issues much more. They think much more globally than the other segments. You find progressive activists across the country, but they're particularly overrepresented in university towns, in cities. The Green Party and Labour Party dominated by progressive activists. Lots of them have left X now and have migrated to Blue Sky and places like that. And they tend to go to more left-leaning outlets such as The Guardian or even independent organisations like Novara for their news. Why are they interesting to us? Well, despite making up 12% of the population, progressive activists are overrepresented in particular employment contexts. So you can see the UK public there. If you look at when we often go in and we do workshops with organisations, and we find a pretty similar pattern whenever we go into public bodies, and also most of our work is with civil society. And you can see that charity policy and comms team, 81% were progressive activists compared to 12% of the public as a whole. They are also, though, much more engaged than average, which means that when it comes to posts on social media, progressive activists generate a lot of those posts. And what does that mean? That means that this group is shaping a lot of societal debates that we are having at the moment. They, as I say, they're engaged. They see their role as unlocking social justice, and in their private lives and personal lives, they'll spend a lot of time doing that. But of course, what we're going to go on to talk about is how that bleeds into an employment context. Now, I should say, I sometimes give this talk or versions of it, and people sort of say, "Oh, you're basically saying, this group is the problem." Absolutely not. Progressive activists are the drivers very often of social change, and lots of the big social change and advancements that we've seen in recent years are the result of progressive activist campaigning. But understanding, firstly, how progressive activists sometimes differ from the rest of the population, and secondly, how that can affect a workplace is quite important. So, for instance, if you look at an issue like migration, which is up there, progressive activists are the only group where people are more likely to say that the government should either keep numbers who are migrating to the UK immigration levels the same or increase them. For all of the other segments, they are slightly more likely to want to reduce levels of immigration. So they're overrepresented, but it makes them outliers. Interestingly, they're not outliers on the economy. and on economic debates and questions, actually they tend to share quite a lot in common with other groups on the need to go to a fairer, more balanced economy. But it is social issues in particular and debates around Britain's history, Britain's heritage, our role when it comes to global conflicts in particular, as you can imagine, something like the war in Gaza at the moment. They tend to have outlier views. And when it comes to those outlier views, they are also, along with traditional conservatives, the least likely to say that we need to compromise with people that we disagree with politically. They have a strong view that's quite central to their identity, that they need to stand up and fight for their views. Obviously, again, campaigning and fighting for your views can be important, but in a workplace context, that can sometimes be quite difficult to navigate and to manage. And they have very different views when it comes to issues around free speech, which is quite interesting because, as I'll show, progressive activists are the most likely to say that if someone makes a mistake on an equality and diversity issue, that you should call them out on that and actually challenge them on it. But on other issues, they're much more likely to back a pro-free speech stance. So when you ask about Palestine action overall, only 33% say that it is a poor use of police resources to try and arrest people who express support for Palestine action. That rises to 66% amongst progressive activists. They are much more supportive of direct action. So, Just Stop Oil, they're the only group more likely to say that Just Stop Oil is a force for good than a force for bad. So strong belief in direct action. And also they have a tendency, and I think this is quite important, to overestimate how many people share their views. Now, you probably can't see all of this from up there, but what's interesting is that it's not that progressive activists think that a majority of the public share their views, but they tend to overestimate support for their views by a factor of maybe 2 or 3. And what that means is that they sometimes skip over the persuading phase. So, for instance, progressive activists think that around 27% think that the UK should scrap its nuclear weapons. It's actually half that. Ditto, we should abolish the monarchy in Britain. 35% progressive activists think 35% of the public hold that view, just 18% do. Again, when you look at other questions around, the government should allow more refugees into the country, only 8% of Brits think that, compared to 25% of this group. So there's an overestimation of how many people share their views. And I think that plays then into how they act or can behave in the workplace. And so when we were doing this report, one of the poll questions that we looked at was, how appropriate were certain forms of workplace protest when you disagree with the actions of management? And what you can see there is that progressive activists quite significantly above the other 6 segments, particularly on things like organising staff protests. They tend to say that that is at least somewhat appropriate. Leaking information, refusing to implement decisions, and resigning in protest. So they're more supportive of that kind of workplace direct action. Again, for an employer trying to handle that, we often say that understanding the starting point of this group is particularly important. Again, now this isn't as much of a variation as the wider public, but again, progressive activists are the segment most likely to say that if they disagree with someone's political views at work, it is better to speak out about those views. And I think that's it. Their expectations of advocacy extends to how they approach colleague relationships in the workplace. And when we spoke to people in some of the focus groups for this piece of work, we spoke to some of the people who said it was important to speak out. They said they didn't want to work in a workplace where people didn't share their views and their values. And again, for employers, that can sometimes be difficult. And that particularly manifests itself when it comes to what you might call institutional neutrality. Progressive activists are the only segment where they are more likely to say that businesses should speak out on political issues, even if they don't affect the core business of that organization, particularly on issues, as I say, like international conflicts, the conflict in Gaza, and you must say we interviewed some charity CEOs for this, and they explained the difficult position it was putting them in. So there was, for instance, a mental health charity where they said there is no way we could put out a statement on Gaza because, we have to work with people and provide support to people who have, very different views on the conflict, and yet staff were threatening almost to walk out if the charity didn't do something like that. So it's quite a difficult situation to navigate. As I said earlier as well, progressive activists also have an expectation that workplaces take not just robust, but I think sometimes quite challenging positions when it comes to equality, diversity, and inclusion. So again, progressive activists are the only segment where you get over 50% saying it's helpful to criticize people when they make mistakes on equality and diversity issues. Most, or in fact, all of the other segments more likely to say that you just make people feel embarrassed and stupid as a result. And again, this can be an area when we've done work with employers where they found particular conflicts, expectations among staff that when people make mistakes, that there is perhaps a more punitive approach than the employer thinks is useful. So, how do you navigate this? Well, I'm not a lawyer, so it is definitely not for me to talk about the legal framework. But in terms of the kind of softer ways of navigating this, what did we find from our discussions? Again, we spoke to charity CEOs and senior civil servants in particular, because that's where progressive activists are most overrepresented. I think one of the things is having clear red lines around what a workplace will and won't tolerate. So some organizations say we are institutionally neutral. We are not going to take a stance on issue. And those that say it from the outset in hiring tended to have avoided lots of these issues. I think the second thing is, how do you create space for people to give feedback without making it seem like decision-making on this stuff is, democratic? Because actually it's not in lots of these workplaces and organizations. One thing that came across very strongly from the conversations is trying to do these things in person. A lot of the employers we spoke to said people would say things on staff intranets and message boards that they would never say in person because you have that online disinhibition effect there. So trying to do that. And then, how do you, and particularly I think for the charity sector and civil society, where progressive activists are so overrepresented, how do you recruit a diverse workforce? And by diverse, we include diversity of thought in that to challenge some of the progressive excess sometimes. And then finally as well, and I'd be interested if any of you have any experience with this, one of the biggest challenges, and again, this was largely for the NGOs we worked with when things broke down, was when boards didn't give backing to senior leadership when they were trying to manage employee activism. They would have very clear policies, and then the board worried about being, in one case, it was like, but I remember my board said, I'm going to be accused of being on the wrong side of history, though, if I don't back them. Didn't back the senior leadership, caused all sorts of problems as a result. So they're just some questions perhaps we could get into in the discussion, but I'll stop there and happy to hand over.
Thank you very much, Luke. If I can hand over to Virginia, but before I do, you all ought to have on your seat or maybe on your lap now a handout that Virginia has produced that she's going to speak to.
Thanks very much, Jason and Rebecca, for having me. It's great to be here, and thanks for the very interesting presentation. The way I'll talk about free speech at work and free speech away from work. And just to start, how do I understand activism at work? I take it to describe a situation where employees express views either at work or away from work that are grounded on deeply held convictions that they have on moral, political, or social issues. And they do that in order to bring about social change. This is how I understand activism at work, and this is what I'll be talking about. These views may be expressed both within the workplace, as I said, and outside the workplace, because the boundaries nowadays with social media are really blurred. So the problem is nowadays, much more than in the past, is that a lot of people lose their jobs because of activism at work, because of expressing views with which others disagree, either at work, in discussions with colleagues, or away from work on social media particularly. So the question that I have is it fair for people to lose their jobs because of activism at work, because of free speech? So we have an example from recent news that I am sure you have all seen. A lot of people have lost their jobs in the US the last few days after the tragic assassination of a political activist because of views that they expressed on social media, particularly on social media in relation to this assassination. The most high-profile one was the suspension of a comedian last week because he joked and he expressed some views criticizing the Make America Great Again movement in relation to this tragic assassination. J.D. Vance, in this context, a big supporter of free speech as far as I knew, he said in relation to the incident, it's on the handout, call them out and hell, call their employer, he said, call their employer for what they post in relation to this incident. We don't believe in political violence, but we do believe in civility. So J.D. Vance is encouraging people to call the employers of those who express views that he doesn't like on social media. That may be offensive or anyway, these views on social media. So of course, these stories are not unique in the US, and they are not only recent. We have had dismissals because of political speech and other types of speech in the UK and in many other countries, particularly in the era of social media. The problem nowadays, perhaps as Luke suggested, and more generally, is that, first of all, there is much more polarization nowadays than there was before, and of course, the great impact of social media. So things that we might discuss with colleagues by the water cooler a few years ago, nowadays we may post them on social media and everyone can see them, and this has made a huge difference. It reaches a huge audience, what we post on social media. So before turning to the law, some aspects of the law that I will discuss, it's important to pause for a moment and think, when people lose their jobs because of views that they express, what we're faced with is a situation where someone expresses lawful views, not illegal speech, not illegal expression, lawful views, but they face the gravest disciplinary action, dismissal, the gravest disciplinary action you can face by your employer. So the question is it right for people to lose their jobs for these issues? Is it right for the employer to be able to decide whether someone's view is acceptable or not? Is it acceptable? Is it right for people to lose their jobs and livelihoods because of something they say, either spontaneously, typically, but more generally because of views that they express that are very often, as I said, lawful views? We have a lot of examples like that in the UK and elsewhere, and in the US, of course. So what is in terms of the legal protection for activism at work, I will primarily focus on the law of unfair dismissal and on the Human Rights Act, human rights law. So as all of you here will know, most of you here will know, the law of unfair dismissal protects people from dismissal, the Employment Rights Act, and it has a test of reasonableness. So the employers have to show that the reason for the dismissal is reasonable. The problem for employees is that very often tribunals and courts give a very wide discretion to the employer. So they find that the dismissals may be very harsh, but they are still fair. So employers generally have great discretion, and the law of unfair dismissal is not terribly protective of employees, even though there are, of course, some cases that are won. One case I had found particularly striking was Gibbons versus the British Council. That's on the handout. I'm not going to. Ms. Gibbons was working for the British Council, and she lost her job because she expressed views against the monarchy on Facebook. I will not go into the details of the case, but it got on the front page of tabloid press, and she lost her job because of her political views. Has anything changed then in the protection of people's views after the incorporation of the Human Rights Act, the European Convention on Human Rights? Do employees have stronger protection than they had under the law of unfair dismissal? So the European Convention on Human Rights Act, protects rights such as the right to freedom of expression, freedom of religion, freedom of association, all these rights are relevant to what we are discussing here. And from early on, from the beginning when the Human Rights Act was enacted, in the case X and Y, that most of you will know, all of you will know very, very early on, the Court of Appeal in that case, Lord Justice Mummery, said that the Employment Rights Act, the protection from unfair dismissal, has to be interpreted in light of the Human Rights Act. The big difference between the law of dismissal, the law of unfair dismissal, and the European Convention on Human Rights Act is that we have a test of proportionality there. What does that mean? It means that we don't have just the test of reasonableness in the Employment Rights Act, where even very harsh decisions are viewed as reasonable. The employer has enormous, great discretion. But there is a more stringent test under human rights law, freedom of expression, freedom of religion, freedom of association. These are not absolute rights. They can be restricted insofar as the employer, in the cases we talk about, has a legitimate aim, and insofar as the disciplinary action in this case, or the measure that the employer takes, is proportionate to the aim pursued. So many of us argue that the test of proportionality in the Human Rights Act, in human rights law, protects the employees more strongly than the law of reasonableness in unfair dismissal. And I think we've seen it in judicial decisions. So how about now the protection of free speech? When is speech and political activism really protected at work and outside work in these cases? First of all, on the handout, you see the Handicide case, Handicide versus the UK. From very early on, the European Court of Human Rights took a very strong and very protective view of free speech, and said that even speech that offends, shocks, or disturbs is protected under the right to free speech, because such is the importance of pluralism and broad-mindedness in democracy, that we have to be willing to protect even speech that we find offensive, shocking, and disturbing. There have been cases in the employment context in the past on these kind of issues. I have two on the handout: Vogt versus Germany and Redfern versus the UK. Vogt, very old cases. Vogt was about a communist, a German teacher. She was a teacher and she was a member of the Communist Party, and she lost her job as a teacher. And the European Court of Human Rights from back then in Vogt said that her dismissal violated her right to freedom of expression because she didn't express her political views at school. She didn't try to indoctrinate her pupils. She was a political activist outside work, nothing to do with her job. She won her case in the European Court of Human Rights. Maybe more difficult cases, Redfern versus UK. These are the case on your handout that most of you, all of you will know. British National Party member, Mr. Redfern, was dismissed from his job as a bus driver because of his political views and his affiliation with the British National Party. He was an active member of the British National Party. And Mr. Redfern again won in the European Court of Human Rights, even though the British National Party is against the European Convention on Human Rights. He took the case, of course, he took his case to the court and he won. And in that case, the European Court of Human Rights again found that the fact that he had no protection from unfair dismissal during the qualifying period in the law of unfair dismissal violated his right to freedom of association together with the right to freedom of expression, I think. So both the communist teacher and more recently Redfern BNP far-right member won. So in both won on the right to freedom of expression and freedom of association. So the two principles that we find in these cases is that people have the right to freedom of expression, political speech particularly. Political speech is particularly strongly protected by the European Court of Human Rights, insofar as they don't bring their political views to work, they don't try to indoctrinate pupils, they don't try to, it doesn't affect their workplace performance. The protection is such that there should always be the possibility to challenge a dismissal through a test of proportionality. The European Court of Human Rights also pays attention to the chilling effect that there may be after a ban of speech, and particularly political speech. These are older cases, they don't have to do with social media, but nowadays I think that social media have made a great difference, and there are, as far as I can tell, a lot of more people losing their jobs because of what they post on social media. So how do we deal with those, and how should we deal with those? I think that by now, in the beginning, it was trickier. I think people couldn't understand exactly who could see their posts. So, people thought, oh, I have a private profile on Facebook, so nobody can see my posts. But nowadays, hopefully, people have understood that, that this is not the case at all. You may post something on your private, personal Facebook page where you only have, 100 friends, and then one of your friends takes a screenshot and sends it to your employer or posts it in public on Twitter. So nowadays, people probably understand that what you post on social media is always public, and it will always be, it's always possible for everyone to see it. In the past, a lot of people lost their jobs simply because they didn't realize that. They thought that they were just posting in a private group. All of these cases that have to do with social media dismissals because of political activism, they can involve freedom of expression. They may involve the right to private life, freedom of association. And again, there, the correct test is a test of proportionality, such as the one that we find, like the test that we find in in all these provisions of the European Convention on Human Rights on freedom of expression and freedom of association. We saw in a case of the Court of Appeal in Higgs that many of you will know. Some of you here are more experts on these issues than I am. We saw in the Higgs case in the Court of Appeal what the test of proportionality can mean in the context of social media posts. Ms. Higgs was dismissed because of her gender-critical views that she had expressed on Facebook. So the court there, Lady Justice Eddy, and then the Court of Appeal endorsed the relevant considerations. What are the considerations for a social media dismissal because of someone's views? It's on the handout on the second page. You can see the considerations there, the content of the speech, the tone used, the extent. Does the worker understand the likely audience? The intrusion in the rights of others, whether the worker said clearly that these are personal views, power imbalance given the worker's position or role, the nature of the business, and whether the limitation is the least intrusive measure that's in the test of proportionality, whether the dismissal, let's say, is the least intrusive measure. I mean, these are generally the right considerations when someone looks at dismissal because of social media activity, because of controversial views expressed on social media. The nature of someone's job, I think, and the nature of the employer's business are all crucial. The nature of the job, particularly, I don't think it's mentioned there. I think this is also relevant. What kind of job do you do? The CEO of a charity working on migrant workers, they cannot really express views against migrant workers on social media, while someone who's just doing secretarial work in an organization has a different role to the CEO. Of course, there are limits. We see there and the limits to free speech, limits to activism at work, and away from work. And the question is, what are the limits? And the limits, typically, we know from the case law of the European Court of Human Rights very well, is hate speech. I don't claim by any means that I can define hate speech, and it's a very controversial issue. In the past, the European Court of Human Rights used to view hate speech as something much narrower than it does now. Nowadays, the European Court of Human Rights has said that there are two categories of hate speech: the gravest forms of hate speech that are not protected under the European Convention on Human Rights, but that there are also the somewhat less grave, that is the case Lilindal versus Iceland, that's on the handout, but there are also less grave forms of hate speech, that may or may not be protected, where the authorities have a margin of appreciation. So nowadays, the European Court of Human Rights is more willing to restrict more types of speech than to accept the lawfulness of restrictions more than in the past, in the definition of hate speech. I think that this is probably worrying, that insults, the court mentions insults and ridicule in the less grave forms of hate speech. And I think that saying that insults and ridicule, I mean, it will very much will depend on the broader context of the whole of a case. But to say that insults and ridicule may be hate speech can be worrying. And it's important. I think it's important to keep in mind the principles in handicide, that free speech may even be speech that some of us may find offensive and shocking. There is a UN document, the Rabat Plan of Action, where the UN tried to identify some principles on hate speech, and it's on the handout, and they refer to the social and political context, the status of the speaker, the intent to incite against the audience, against a target group, the content and form of speech, the extent of dissemination, and the likelihood of harm, including the imminence of harm to a group. And this is a more stringent test of what constitutes hate speech than the Strasbourg one. So it's important to remember also that today we're talking about hate speech at work, and whether, in my talk particularly, whether people should be losing their jobs because of exercising the right to freedom of expression. We're not talking about whether this should be a criminal offense in some countries. We're talking about whether it's lawful to lose your job because of views you express on social media. And what concerns me is that the possibility of arbitrariness in all these cases is great when the employer decides whom to dismiss because of views that they find disagreeable or that others find disagreeable. The employer's reputation, I think we have to be very careful whether, whether, because sometimes the employers say, that it damages our reputation. I think we have to be very careful with that. First of all, we know that very often sometimes employers use the reputation, damage to reputation as an excuse. There's a case I have in the handout that Jason likes. The Mason case, I'm not going to talk about it now. I just mention it because it's an interesting case. We know that the employers may just start going through your social media because they want to suck you anyway, and that's not right, obviously. But also we know that, if we have a right to free speech, then even, the fact that a lot of people on social media may not like what we say, the majority even may not like what we say, that's not a reason to restrict people's rights, the right to free speech. It's exactly why we had in the first place human rights law. The protection of human rights law is exactly in place in order to protect people from majoritarian preferences and from prejudice and from majoritarian preferences. The final point I want to make is sometimes when I read about these issues online, particularly, and I look at human resources advice and websites, I see that they say, don't worry, employers, it's not a problem. Just draft clear guidelines for the employees so that, in this way, I'm glad you're, finding that this is wrong, because I think it's, I hope you agree that it's wrong. If you have a right to free speech, the employer cannot just draft clear guidelines saying that, oh, forget it, you shouldn't exercise this right to free speech on social media, for instance. If you have a right to free speech, the employer just does not have a right to restrict this right by drafting clear guidelines. And we have authority for this in the case law of the European Court of Human Rights, a case that involved the right to private life, the Barbulescu versus Romania case, where the European Court of Human Rights said that the employer cannot, through guidelines, cannot restrict human rights, the right to private life, or the right to free speech, in our case, to zero through their guidelines. So the employer does not really have the right to adopt guidelines simply telling you that you don't have a right to exercise convention rights. So I think that this is the wrong approach. So just to conclude, I think activism at work, in the way that I described it, protection from dismissal because of activism at work and away from work should be protected strongly, because having no right to free speech can undermine individual autonomy, of course. We're talking about people who have strongly held views, and that's why they're activists. It undermines individual autonomy. It undermines democratic values and pluralism. I think if employers want to do something about all these things, they should try to educate the workforce about diversity of views and try to find common ground instead of imposing disciplinary sanctions and dismissing people whose views others dislike, with, of course, some limits on hate speech, which, as I said, is a very difficult question, because we really want to protect people from this. Otherwise, we may end up with authoritarianism at work instead of activism at work. So thanks very much.
Thank you very much, Virginia. Yeah, if we can start with a round of applause for our speakers. Now, there was certainly a lot in both of those talks for everyone to ponder. I'm sure that there'll be some interesting questions, and I'm sure there'll be some challenging questions to the panel. Thankfully, as the chair, I can just point to speakers and say, can you answer this? Can you answer this? And keep my own counsel on it. But can we have, is there a member of James? Iris, I can see you're looking. You can either, well, no, it wasn't to be the first question. It was somewhere or other. We've got a, there we go. We've got a, fine. We've got a, do you want to be the, there is. Yeah, can we have hands up for whoever wants to ask a question? I can see a hand up. Is that Alex? Right by you. Can you also introduce yourself, Alex, before you, sorry, I've introduced you already just now, sort of, but before you ask your question.
Whether research done any breakdown of how those categories, 7 trials, how whether there's any figures about how HR
it is so the only survey we've done which is adjacent to it is EDI professionals, where it was, I think it was sort of 95% were progressive activists. And of course, that's quite interesting because they're the group who are almost kind of, in some cases, setting some of these boundaries or delivering the training. And of course, if from their starting position, they're outliers to the rest. But I'll go back and look at the data and see if we've got a breakdown by HR professionals as well.
Sorry, Iris, we're going to make you run. It's really great to be able to do the PRKC to sort of, yeah.
Thank you. Rob Lewis, Mishkondoea. My question's for Virginia. So you talk about the importance of protecting free speech in the workplace, and just linking to what Luke had told us about progressive activists in the workplace. And not only do they sometimes hold views and behaviours in ways that are quite censorious, but they also represent the majority in some workplaces. Your conception of dealing with free speech, does that not lead to some workplaces, instead of worrying about the authoritarianism of the workplace, of the work, the employer, what you're having is the authoritarianism of the workplace activists? Because people exercising their free speech in ways that actually silences everybody else is a form of infringement of free speech in and of itself.
I mean, if, yes, thank you. If, I guess, the question is, if they put pressure on the employer to take disciplinary action, I think just
act in ways that are intimidatory of everybody else's free speech.
If people harass other colleagues at work, then this is unlawful. I mean, this is a problem, harassment. If this is what you have in mind, otherwise, if they just disagree and they're very vocal, people can be vocal about their disagreement. Ideally, not at work.
Harassing their colleagues.
I think you cannot harass your colleagues. It's unlawful to harass your colleagues. So. Harassment in the workplace is a limit to free speech, I think. I don't suppose Yes, I don't suppose that anyone would disagree on that also, that harassment is a limit to free speech. But at work, the question is, of course, another question is, what if someone says that, you know, because of the Virginia's post on social media, I'm feeling harassed at work, and I don't, you know, I mean, unless it's a personal attack on someone on social media, then I don't, you know, it depends obviously on specific examples. Like it's hard to see how you can really be harassed simply because someone expresses views that you disagree with on social media.
I think that, yeah, I think that is often the tension for employers. It's, I mean, in Higgs, for example, it was a parent that was complaining, but I think lots of employers, they get internal complaints from employees who are saying they're being harassed. And when you have these very divisive subjects, gender critical being one of them, then you have somebody who is saying, I'm entitled to express my lawful views, that's my freedom of speech. And then you have individuals in the workplace who says, this creates an intimidating and hostile environment for me. And it's that balance that I think employers find very difficult and then quite frustrating potentially when they're then defending cases in tribunal on freedom of speech when they've had this internal tension of trying to protect other employees.
Can I add something else on this? I remember this case where that one case I've taken to the European Court of Human Rights with a colleague, George Letzas, IB versus Greece, where someone was HIV positive. And he said it to his employer, and anyway, his colleagues found out. And then the colleagues put a lot of pressure on the employer to dismiss him. The employer, because they said, we don't want to work with someone who's HIV positive, we'll all get HIV. They didn't clearly understand how it was, what was happening in that workplace, but they clearly didn't understand how it can be transmitted. So the employer brought a doctor who gave them the information on the HIV. They still didn't want him, and she dismissed him. We took he lost in Greek courts because the courts said that it wasn't the employer who was prejudiced and who was discriminating, but it was the pressure from the others. It was because of the pressure from the others. And we won in the European Court of Human Rights that it was discrimination on the prohibition of discrimination together with the right to private life, Article 14 and 8. I mean, it's the employer sometimes has to take the burden. It may be that the employer has to really bear this burden to educate employees, and you cannot dismiss others because of prejudice or because of strong difference of opinion. I know it's difficult, and I'm sorry for the employers, but not that sorry as for the employees.
But sometimes, I mean, again, in some of the, like when we've been speaking to like associates, it is ground organizations to a halt, right? It is not that simple. It is someone say, it is junior staff, often junior staff, I shouldn't generalize, but saying, I won't work with that bigot because of their gender critical views, until you get rid of them, we're not going to work. I mean, gender critical is just one example that you could use, but we heard stories that, and then you're in a situation where it's basically in deadlock. And if you look at the charity sector in particular, there've been whole organizations basically been paralyzed by this type of thing. And then what do you do as the employer? I mean, it's not, I guess in that case, it's not a legal question, it's a organizational management one, but
yeah, what do you do? I don't know, you train people. I mean, people will have views, you just get them to understand that there is difference of opinion. And
I think, James, you had a question. Iris, can you, come down to James Murray?
Hi there, James Murray at Dole Clayton. I've got a slightly more specific, sector-specific question, if that's okay, in higher education. So this is in light of the Higher Education Freedom of Speech Act. Now, the regulator has taken a very expansive definition of free speech in its regulatory guidance and seem to sideline a lot of the convention principles which you've been talking about. The Act itself seems to envisage a mirroring of the convention, including the 810.2 limitation principles. So my question maybe is do you think the OFS has got its definition of free speech wrong in the way it's drafted its regulatory guidance, or otherwise got its interaction with other convention principles wrong in the way it's framed that guidance?
So I have not read the guidance, and certainly, yeah. So, I'll have to read it. If you want to tell us a bit more detail on how it conflicts with other convention rights, I can tell you what I think now, but can also read it and we can discuss it.
Yeah, we'll take it offline. We won't bore I would bore everyone else if you got me into that.
Okay. We can talk about it afterwards then.
No, that's fine. I mean, well, you've written a very interesting article in it in the last couple of weeks, haven't you? So I promise you it's not boring. And if you speak to James afterwards, then he'll be glad to speak to you on that. Can I see any more hands up? There's right at the back. This is good. We're making Irish really.
Let's get her steps in.
Yeah, absolutely.
Hello, my name's Kate Logan. I'm from Historic England. So my question is from the perspective of public bodies and government departments. So I know, Virginia, you were saying it's not a defense, or it's not employers can't restrict free speech rights by, publishing guidance that says it's not appropriate in this workplace for reputational reasons. So I guess my question is, do you think the same thing would apply in terms of government departments, public bodies, where there is an expectation of impartiality and political neutrality? How far can that infringe on the rights to free speech of the employees?
Shall I just repeat that question? I know that some in the front didn't hear. I'm going to rephrase it. I'm sorry if I get it wrong. You'll tell me if I've done so. So it was a discussion about the fact that employers, or what Virginia said about employers not being able to restrict free speech by publishing guidance. And the question is that from a public body perspective, where you have political neutrality in place, does the same apply to those bodies, or are there different considerations? Yep, great.
Yes, no, thank you very much. Yes. So, yeah, I only had 20 minutes, and there's so much to say about these topics. Yes, I think the nature of the employer, what type of employer you have matters. There's no question. So, of course, there are employers such as, we know the BBC can have guidelines for its employees. Then can it also impose these guidelines on Gary Lineker? That's a different question, of course, because, or is it just for political commentators? So I think, yes, I think in French, they call them organisation de tendance, ideological enterprises. We can say, you can say that there is a parallel there. There are organizations that may promote a specific worldview. And these organizations may say that employees, both at work and away from work, have to live their life in public, at least in a way that complies with this worldview. And this is fine, yes. And then the nature of the job also matters. As I said earlier, it's different if you're the CEO of an organization, and it's different if you're just doing secretarial work, and you have, so so in ideological organizations that have a specific ideology, or in the public sector, a duty of neutrality can be compatible with the European Convention on Human Rights. And we have case law of the European Court of Human Rights on these. Two are on the handout, Obst versus Germany and Skuth versus Germany. These are interesting cases. And the Vogt case on the handout is relevant to that. But also the nature of the job, what role you have in the organization is also relevant. And, Gary Lineker, perhaps the BBC guidelines on neutrality should not apply on the social media of a sports commentator.
I often wonder also with guidelines on neutrality, whether they're actually seeking to be neutral, or they have someone in mind when they're, say, for example, in the HBTA case, where you're looking at dress codes, and the European Court of Human Rights, or the CJEU in that case, we're looking at on a basis of this is just completely being applied neutrally, and one wonders whether actually the motivation behind the restrictions on the dress code were specifically looking at those of a certain religion who the employer decided that they didn't want to be wearing their traditional dress in order, well, actually, either with members of the public or indeed in the back office. Luke, you, of course, have lots of experience of being in government departments with neutral policies, no doubt. So
Yeah, and I think it is. And look, this is, I mean, two things I would say. One is we've actually looked quite a lot at public opinion on institutional neutrality and organizational neutrality. And one of the things that I will say is, I don't think this will surprise you because it's normally where public opinion comes out, but public opinion is much more authoritarian than the law at the moment. The public, if you ask them, quite strongly believe that employers should be able to discipline you for things that you say at work, and they think they should be able to have quite restrictive speech codes. Interestingly, we've also seen a trend towards a wider desire for institutional neutrality across sort of political issues in public opinion. So I don't think anyone has escaped the debate about flags at the moment, but it's really interesting that even compared to a few years ago, there is now a view that public bodies shouldn't be displaying pride flags that they were previously. Shouldn't be displaying the one exception, the one international flag they will sometimes allow is the Ukrainian flag, but all other flags basically shouldn't, and it should just be the Union Jack. So there is that kind of strong preference. But I do think there's a further point linked to, you know, when I was in Ofsted in particular, where you're working for a regulator, there is a real danger, actually, if a regulator isn't seen to be neutral. And, you know, a big part of our work there was the work tackling, which opens up a whole other area of law, you know, unregistered schools, which were often run by minority religious groups. If you're seen to have a particular position on some of these issues, it totally undermines the work of the regulator. So, I mean, there has to be a sort of, you know, sort of feasibility test as well.
Rebecca, do you want to come in on this question?
Yeah, I think it's well, again, I'll come from sort of an employer's point of view that it's natural, I think, for employers to want to have guidelines and policies to give a structure to their employees, and to say you can't reduce free speech, nothing by policies and guidelines is all very well, but where is that balance for an employer when they are trying to give a steer to those conflicting views in the workplace? But I think on the neutrality point as well, that often is going to be an issue about whether the individual can be said to be expressing opinions, etc., that would be associated with their employer if they're doing it in a personal capacity and outside the workplace.
No, absolutely. And I mean, I think also neutrality and policies are probably going to come up in Miller in a couple of months when it's in the EAT, because certainly at the ET level, the question of what prescribed by law means within at the time Page, but now the Court of Appeal judgment in Higgs. I think in Higgs, Lord Justice Underhill says that was very simple. You know, you've got the contract,
yeah,
and that's the end of it, and you know, simple as that. But there were certainly concerns in Miller in the Employment Tribunal that a decision maker may be found to be discriminating because something happens to be in a folder somewhere that hasn't been seen by the employee, that they don't know about, and suddenly they're branded a discriminator for something that's not their fault at all because it might fall within some crack in what's prescribed by law. Virginia, you wanted to ask Luke a question on
I wondered these last few days after the dismissal of a lot of people in the US that's been covered in the news, whether what you described as a progressive activist is the most left in your slide, whether the dismissals that we see in the US, whether this may affect their thinking. Because I had a discussion with a colleague a couple of days ago who told me, I was telling him about this discussion tonight, and he said, oh, you were consistent in your support for free speech from early on with Redfern. I'm not a BNP. I find Redfern's views, BNP views, abhorrent, but I was back then in favor of the right to free speech and some protection from dismissal, always for that right. So it may be, I wonder whether we may see people now seeing what's going on in the US, becoming more open to the idea that, well, it sounds like we really need free speech. You can't just let the government decide or the employers decide whether your joke was insensitive, for instance.
I would hope so, but people are very good at kind of finding justifications for why it's different. And the reason I say that actually is on the flip side, it's been quite interesting seeing some of the reactions from some of the people on the political right when they've been challenged with, but didn't you say cancel culture was terrible? You know, haven't you campaigned against this? And the justifications have been, oh, well, there's a difference between you know, stating your beliefs and saying, you know, and celebrating political violence, and that's the way that, you know, it's kind of flipped. So I would hope, but I'm not hopeful.
Are there any more questions? Audrey, have we got the mic? Sorry, has the mic been stolen? No. Yeah, Iris, can you come all the way down to the front now? Thanks very much.
Hello, I'm Audrey Ludwig. I'm equality non-practicing solicitor. And I'm quite interested in this because to a certain extent, we haven't really looked at a lot of the sort of recent equality law cases that essentially have been around free speech. And there's been quite a number of cases, particularly on sex and gender identity. And I was just wondering, to a certain extent, has the problem you described, you said EDI is actually full of progressive activists, and that seemed to mirror a situation where there was a lot of misrepresentation of equality law that was going on, that there was a sort of sense of we're getting ahead of the law, or we're going to create a new way. And to a certain extent, will the challenge to EDI now actually create a situation where we might end up with a slightly more balanced, a more genuine neutrality than the sort of very progressive interpretations that have happened over the last few years, to the point where in Mead and Westminster and Social Work England, which is the first instance case, there was a lot of criticism of the regulators for imposing ideological views as a starting point for their investigations.
I mean, from again, so we actually today have a report out on public attitudes to EDI, and I think the way you've described EDI is closer to where the median member of the public would like it to be, which is very much sort of rooted in mutual respect and tolerance, rather than being seen to advance a political agenda beyond the law, and also to make sure that EDI is seen to genuinely support disadvantage across the piece. We found that one of the biggest factors in undermining support for EDI was that people felt it didn't apply to socioeconomic issues and class, and that, you know, in particular, white working class people weren't supported by it, and of course EDI should. So I definitely think that is a shift. There was a strong desire, again, in the research for having, you know, that you would have to tailor things to specific organizations in terms of EDI, but with some quite clear guidelines. So for instance, and so I use this just because it was a poll question that we had. We asked about the Supreme Court case and whether the quite we would call them, is it strict guidelines or quite definitive guidelines on things like bathrooms from the ECHR were European Human Rights. No, I can never remember which one. Not the Equality Human Rights Commission. That one had too many acronyms. Were right to be so prescriptive. The public backed that level of prescription actually, because there was a sense, when we talked about it in focus groups, there was a sense that it's just too unclear, and otherwise you get other people advancing different views about what it might or might not mean.
Becca, have you had experience of EDI within your cases on this area?
I think not in the way Audrey is referring to. Fortunately, perhaps that has not been an additional challenge for me. But I think you're right about people wanting certainty and things that are too unclear. But I think actually, one of the issues actually in general public perception is we have these cases, these dense legal cases, long legal judgments, and then on social media itself, you get these tidbits or snapshots or assertions that the case says this, that, or the other, that then become sort of into circulation, which are really not picking up on the nuances that us employment lawyers no doubt do, and that creates a level, I think, of concern for people as well.
I think we've probably got time for one more question. You do, because otherwise people who are watching, the people online, I should say, have been very, very kind to the audience who have made the journey here, and they've let you have all of the questions. So we thank them very much. But
it's Lee Gabby, Braier Orleans. Just wanted to turn it around, the focus around slightly to a specific question around if a minority or threatened group within a workplace, I say threatened by like world affairs or the current conflicts, approach the employer and say, we're feeling threatened inside the workplace and outside. Can you put out we think you should put out a statement in solidarity and support. How should the employer respond to that? I'm thinking one specific circumstance was actually a law firm who did feel, the pressure and compelled to put something out there but by putting the statement out there, they supported one group, but then, it then sort of gave rise to another, the sort of the group on the opposite side.
Can I give that to you first?
Yeah.
We're not being supported here, so it kind of seemed to, sort of cause more issues than answers.
I think wherever possible, try and avoid those kinds of statements as an organisation, especially if it's not specific to your organisation. I mean, a law firm, for example, why should they be putting out, I'm not sure the exact circumstances, but why should they be putting out a statement? And you are going to run into trouble inevitably if you will have members of your workforce who have an opposing view to that statement. So I would avoid, if possible. Easy for me to say. It can be more difficult when you have pressure on the ground. I appreciate that.
I mean, the problem is, look, we'll say, but the problem is that, then the next question is, okay, but you put out a statement on this, but then why did you not also put out a statement on that? And we've had this at the university as well. Yes, I agree, but, others have expertise, yeah.
No, I think there's I think, again, from a public opinion perspective, there's a relevance test there. Is it relevant to the work of your organisation? And in lots of cases, it won't be. If you're a humanitarian charity putting out a statement about a humanitarian issue, of course, it's your sort of bread and butter. If you're a law firm doing that, should you be doing that? And as you say, it generally opens up more problems. And I think the thing to remember is, just going back to the segment, because progressive activists are more vocal, they are likely to be the ones who come and put the pressure on people to make a statement. People in the other 6 segments might be like, I don't want that at all. But what gets represented is the loudest voices.
There is a real danger, having made one statement one way, that if you then don't make a statement the other way, why have you not done that? Have you treated people differently because of their beliefs or their other protected characteristics? And therein lies the danger and a lot of litigation that I suspect a lot of us in this room are involved in, have been involved in, or are going to be involved in. And that would probably be an excellent topic for everyone to discuss when we go for drinks and canapes across the way in a moment. Thank you, everyone, for coming. I hope that's been as engaging and interesting for you as it has been for me sitting up here and listening to everyone. Can we please just give one final round of applause to our speakers and to our panel? Just in terms of admin, there will be feedback forms. We always make a plea for you to fill them in. Tell us what you liked about this, what we can improve, etc., which can be that you'd have liked some different canapes. So when those are emailed to you, please do try to fill them in. If you'd like to join us across the way for some drinks and some food, there are other members of Chambers waiting there ready to take your difficult questions as well. And thanks very much to everyone for joining us.